In a medical malpractice case, when I am questioning the doctor whom you have sued, can I ask the doctor whether he violated the basic standards of medical care? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In my opinion, the answer is yes. Not only should I be asking that question, in my opinion, I think it's a requirement. So let me tell you what this is all about. When you bring a lawsuit seeking compensation, seeking money as a form of compensation for all the harms and losses and injuries that you suffered because of a doctor's carelessness or maybe hospital staff and their carelessness, now, during the course of the lawsuit, I will have an opportunity to question the various people whom you have sued. And that could be doctors, it could be nurses, it could be physician's assistants, people in the hospital, people who are affiliated with the events that transpired, leading you to suffer these various injuries. During the course of these depositions, which lawyers also call examinations before trial, it's really a question and answer session that's given under oath and in pre-COVID times in an attorney's office, in the defense lawyer's office. Nowadays, it typically happens on a Zoom video call. The answers that the doctor provides to my questions represents his sworn testimony. And something you should really know is that that sworn testimony, even though it's given in an informal setting on a Zoom video call, carries the same exact weight as if that doctor is testifying in court, in front of a judge, in front of a jury. The reality is that during this deposition, the doctor is on the call, the doctor's attorney is on the call, I am on the call, and any other attorneys affiliated or associated with this case. In addition, there is a court stenographer there to record all of my questions and all of the doctor's answers. Now, I asked the question at the very beginning of this video, is it appropriate for me, as the attorney questioning the doctor, to ask him whether he violated the basic standards of medical care? And my answer is, yes, it is. Now, what do you think the doctor's going to say when I ask him, hey, doctor, did you depart from the standard of care when treating my client? You know what he's going to say? Of course not. I did no such thing. He's going to deny those claims. How do I know that the doctor is going to deny all these claims? Because at the very beginning of the case, when we started your lawsuit, the doctor's attorney responded to our allegations and denied all of them. In addition, the doctor's attorney called me up and said, hey, Gerry, just want to let you know, you're barking up the wrong tree. This doctor did absolutely nothing wrong, and even if he did, he didn't cause or contribute to your client's injuries. So I know from the very outset, oftentimes, that the doctor is going to deny these allegations. Now, why is it important for me to ask this question during this pretrial testimony? I want to establish that there is a clear conflict. Our expert or experts who have reviewed your records confirm that you have a valid basis for a case. They confirm that the doctor violated the basic standards of care, and as a result of those departures from the standard of care, you suffered significant harm and injury. In contrast, the doctor is now saying, I did nothing wrong. I did not depart from the standard of care, and nothing I did caused or contributed to your client's injuries. And the doctor will oftentimes get very defensive when I ask this question. Doctor, did you depart from the standard of care? Now, can I ask that question as my very first question when I start questioning the doctor at his deposition? The answer is, I could. Is it a wise strategy? Oftentimes, no, it's not the best strategy to come right out and start off a deposition by asking him that question. Would you like to know why? It's because I know the doctor's going to deny it. I know the doctor's going to dig into his shell and get further back, and he's going to get very, very defensive. There are better strategies to asking questions. And the better questions, in my opinion, are to get the doctor talking. And I'm not there to trick him by any means. And his attorney would certainly object if I were trying to do that. But I want to understand from the doctor if he has a solid knowledge of the medicine involved in the case. I'm entitled to probe the doctor's knowledge of medicine. I'm entitled to ask him definitions. I'm entitled to ask him how certain procedures are performed as they relate to this case. I am entitled to ask him questions for which he, as a medical doctor with many years of training, should have easy knowledge and should have clear answers to. Then, once I establish that the doctor has this medical knowledge, I can now begin to ask him what the standard of care was for similar scenarios to yours. Doctor, if a patient comes into the office with the following complaint, would you agree? Good medical practice requires you do A, B, and C. Would you agree, doctor, that after learning that information, it's good medical practice that now you do X, Y, and Z? And now I will take the doctor step by step to establish his understanding of what the standard of care was in certain scenarios with certain facts. And those facts are going to be very similar, if not identical, to the facts involved in your case. But I'm just talking generally now. I want to establish globally what this doctor understands, what he knows from a medical perspective, and then, after I get a good sense of whether or not this doctor has a real understanding of the medicine and what the standards of care are, then I will slowly get into the facts of your particular case. When I go through the various facts of the case, towards the end, when I have now established and understood why he did what he did, and asked him to explain to me in detail every single step of what he did, at various points toward the end, I will likely ask him opinion questions. And many times I'm going to have to ask him hypothetical questions. Now, why is that? I'll tell you why. Because oftentimes there are factual disputes. The doctor may dispute something that my client said or did during a particular office visit. And if the doctor believes our set of facts, if our set of facts are more likely true than not, now I'm going to ask the doctor to give me a standard of care. What would be appropriate care in that instance? Doctor, I want you to assume that the following facts are true. That Mrs. Jones on January 2nd came to your office and made the following complaints. Would you agree that if she had made these particular complaints, you would agree that the standard of care requires that you do A, B, and C? True? Now, the doctor's going to argue with me and say, but that's not the case. That's not what she complained of. To which I will likely say, doctor, I understand you disagree with certain of the facts that my client has recalled. But I'm asking you for this question to assume that these facts are true. Knowing that these facts are true for the moment, would you agree that good practice requires that you do the following things? And the doctor has to agree. If he doesn't, he's going to look silly. He's going to look like he's trying to hide something. Okay? So I will persist in trying to get a straight answer from the doctor on these opinion questions. It's critically important. And doctor, would you agree that a physician such as yourself who fails to do A, B, and C in light of the patient making the following complaints, that would be a departure from the standard of care? Would you agree? And again, the doctor is likely going to fight me on the hypothetical questions and the facts upon which it is based, because he doesn't want to admit that if our set of facts are true, now he violated the basic standards of medical care. So going back to the title of this video, can I ask the doctor whether he departed from the standard of care? In my opinion, the answer is absolutely. Now let me share with you something that you may not know. Asking the doctor these hypothetical questions are critically important, and here's why. If I am able to get the doctor to accept various facts that we present, and now he answers the questions and gives me the answers that are favorable to us if our facts are to be believed. Now, after we put the case on the trial calendar and we notify the court that the case is technically ready for trial, many times the defense will do everything in their power to try and get your case dismissed before we ever reach trial. That's known as the defense making a motion for summary judgment. When they do that, now they're basically asking the court to throw your case out because there are no factual disputes. And since there are no factual disputes, according to their argument, the judge is only making a decision on the law. And based upon that, they'll argue there is no possible reason that we should be allowed to go to trial and present our case to a jury of your peers. Now, how does the opinion questions that I've been asking affect the defense's ability to present this motion for summary judgment to try and get your case dismissed? What do we know so far? We know that my client has already given pretrial answers to questions that are posed to her in a deposition. We also know that the doctor has given testimony where he's answered my questions. If my client's answers are to be believed, now we've established that there are certain facts that the doctor disagrees with. We've now established that the doctor does not believe my client's version of the facts. If I can establish, as in this deposition example, that the doctor did not do certain things, and he agrees with me that failing to do those particular things in light of the patient's complaints would be a departure from the standard of care, Now I can reply to the defense's summary judgment request and tell the judge, listen, judge, there are clear questions of material fact here. My client said she did A, B, and C. The doctor totally disputes that. Our expert said that if she did A, B, and C, that clearly the doctor departed from the standard of care, causing my client harm and injury. The doctor himself, during his pretrial deposition, recognized that even though he disputed our version of the facts, that if our version of the facts are to be believed, then guess what? Failing to do those things we claim he should have done, that represents a departure from the standard of care. So it helps us oppose the defense's request to throw your case out for summary judgment. So this is another critical reason why it is so important to ask opinion questions. So why do I share this quick information with you? I share it with you to open your eyes and help you understand how these malpractice cases work in the state of New York. You know, I realize you're likely watching this video because you wanted to see the beautiful scenery. You know, I realize you're not watching this video for the scenery, but instead you're watching it because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is to pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Now, join me for a few seconds. I see that there is a turtle on the beach here. Let me show you. It's wild. Hold on. What you see here is a turtle on the beach making its way across. It's pretty wild. And this is a little bonus for the video that I've been shooting. Look at that. He's just hanging out, making his way across. Awesome. Well, that's it for today. I hope you enjoyed this video. Have a wonderful day.